Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I'm your co-host, Thomas Vick, joined by the other co-host, Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. Enjoying the fast approaching middle of March. My goodness, it turned around. I was like, wow, we are going. But the weather's been a little bit nicer. You're starting to see the grass green up a bit. See some flowers outside. And I was reading an email this morning that talked about kind of the benefit of being outside, because I think the statistics cited in the article was like 92% of us spend most of our time inside now. And I was like, yeah, it's kind of nice to be able to get outside here a little bit. And we've got like the eclipse pathway is running through Hamilton County here coming up, which is kind of exciting as well. Another reason to get outside and see what's going on.
Yeah, so many of the school systems in the area, even on the south side as well, are either canceling school or they're going to have like online school that day. So I'm not exactly sure what I'm going to do, but I know I need to get some eclipse sunglasses so I don't go blind on that day. But
that's right. It probably should be some sort of disclaimer on the end of our podcast that says, don't look at the eclipse without the appropriate eyewear and protection.
Don't look at the sun, don't fly too close to the sun, something like that.
We'll put a link in the show notes to where you can go to Amazon and peruse that or something. But
there you go.
No, we're actually going to try to get outside as a group that day around that time. So I've asked staff not to set any appointments on that. So if you are trying to get a hold of us, we could potentially do a consult, I guess, out in the parking lot or something. But maybe we'll wait for that to go, since it's sort of a once in a lifetime opportunity, at least through central Indiana here.
There you go. There you go. Well, it is spring, and the topic of the blog today was spring into estate planning for newlyweds. And we have some things to discuss about what married or to-be married couples should kind of be thinking about as they're planning their wedding, and then also once they're actually married, what should they be thinking about? And that really is a good time in life. We talk about big events in people's lives as being the time to think about estate planning. And it really is a great time to think about doing some estate planning. What are some things that, initially for people that have never been married before should think about when it comes to their estate planning when they get married?
Yeah, a lot of this, I guess, is under the presumption that this is a younger couple, like you said, getting married for the first time, and they're typically not, and I wasn't certainly at that stage, thinking about how do I protect my assets, if something happens to me, or how do I provide for my spouse if, we have a situation where a tragedy occurs, and or I certainly wasn't thinking about incapacity. What happens if I'm unable to make decisions for myself at that time? And I definitely didn't have an issue with potential taxes in terms of the overall value of the estate. And so, a lot of these are sort of reality checks that come after you get into the marriage scenario. And so I think it is good to take a look at a couple of those items and really think that through, whether that's through premarital counseling, where you're having that opportunity to talk about the finances and those kind of things, which can be one of those most challenging discussions to have in a new marriage situation, because maybe you've never had money to manage before because now you got your first jobs and those are happening, or you've been out working for a few years and now you're getting married and you kind of develop that independent style. So really having that question is really important about, okay, is what's mine, or is what's mine ours, or is what's mine yours?
Yeah.
And try to figure that out from the front end, which can help alleviate issues while you're working through the marriage life.
Yeah, one of the factors to be thinking about with estate planning for newlyweds is protecting the spouse. And one of the more common ways to do that is to make sure that the spouse has a house to live in. Maybe, one, say the husband is the has a house, and maybe the wife has a house too that she sells to move in with the husband. Make sure that the wife is now on the deed to the house. That might be a simple step to do, but probably very wise to do, because in most situations that's what the married couple wants for each other. And then doing a will that essentially says the same thing, that everything goes to the spouse first, and then if not, then to the family members of the husband or the wife or what have you. So that, I think, is one thing to do. Get the house titled the way that you need it to be titled. Don't just let time slip away and not think about that, because we don't think about deeds on houses very much. We don't think about, well, is my name on that? But this can serve as a reminder of making sure that the deed says what we want it to say if something unfortunate were to happen.
Yeah, and that's a great suggestion as you maybe purchase your first house together as a couple, right? So maybe they're utilizing one of the couple's income and looking at that because they have the job or have held it longer or something. And so their credit worthiness is maybe a little bit more developed. And so you wonder, well, I'm only on the mortgage, but are we both on the deed, right? And that's kind of the point there, is making sure that each spouse is adequately protected in that scenario. And it kind of brought to mind how we protect the other spouse a lot of times as a younger couple is through life insurance. And so what you want to think about on those types of benefits, whether it's a retirement plan or something like life insurance that can have a beneficiary designation, is make sure those beneficiary designations are up to date and reflect what you would like to have happen. Because if you named a family friend or your mom or dad because you first had that job and didn't have anybody else to list as a beneficiary, now you're married and something happens, that beneficiary designation still controls. And so that's one that can get overlooked in that as well. So just make sure some of those practical steps are taken there. And then I think, as you mentioned, just having that foundational plan in place is really helpful, as really a gift to each other to say we're taking care of each other in the event something happens to us. And I thought you kind of laid out really a good list here. There was about 6 different documents in your blog post that are things that we've talked about on the podcast before, but just kind of something to really think through in terms of getting those documents in place.
Yeah, so we just kind of run through them quickly because we talk about these documents quite often on the podcast. But here's the list of estate planning documents that newlyweds should consider: last will and testament, a prenuptial agreement, maybe, a durable power of attorney, a healthcare power of attorney, a trust, and then maybe some other issues related to being in a blended family. So who's going to take care of the kids? That kind of stuff needs to be considered if it's a blended family. And a couple of those points there, a prenuptial agreement and blended families, those are unique situations because of the multitude of factors that come with those types of situations. So let's talk about a prenuptial agreement, and when does it make sense for a prenuptial agreement to be entered into prior to marriage? Emphasis on prior to marriage.
Yeah, it doesn't do you a whole lot while you're in the marriage, right? Because then you have a post-nuptial agreement, right? So yeah, it's really, and it's a tough decision and conversation to have, because on one hand you're saying, hey, we trust each other and we're entering into this covenant relationship together. And on the other hand, you're saying, well, here, sign this contract as to what happens. And so many times you will see this in a second marriage situation, be that after a dissolution of marriage situation or a preceding spouse has passed in death. And so now you've got sort of an asset base for that family unit that you want to protect and make sure that is there. Or perhaps it could be that you stand to inherit a significant sum from your family members or as a beneficiary of a trust. And there sort of needs to be some protection in place from that standpoint. So The prenup is really kind of an agreement before you get in through the engagement process to the marriage process that says this is what's going to happen with this type of asset class, no matter what, essentially. And you're both parties to that agreement have to know what's going on. They have to disclose the assets. They need independent representation as part of that. So each of their interests are being represented as part of the transaction. And so it can be very beneficial in the right circumstance. And so it kind of requires a little bit of a tightrope walk when you're having those conversations to begin with. But definitely a great tool if some of those circumstances are considerations for your situation.
Yeah, and to understand what exactly a prenuptial agreement covers, I think individuals need to. Do I need to?
You're good.
Okay. So even if there is, a spouse that is provided for in a will, the spouse can actually elect against the will, which means that they can get up to 1/3 of the individual's estate by filing something in the probate court.
Yeah.
And so the surviving spouse is entitled to $25,000 plus possibly a 1/3 interest in the individual's estate. And that's usually the top two topics, I would say, in a prenuptial agreement, saying, I'm waiving that right to my $25,000 and my 1/3 election, and I'm just going to be satisfied with what I have in my own name right now, and that's going to go go according to my estate plan. And if I give my spouse anything through my estate plan, that's a bonus, but I don't have any obligation to it. And so, if a couple really wants to keep things separate, that prenuptial agreement is really incumbent. We sometimes think, well, is that a family law issue? But it's really an estate planning issue that estate planning attorneys work through.
Yeah, and it's both, right? I mean, you're kind of looking at that scenario where, again, in the right circumstance, it can make sense, and you kind of come to the table on either side of that negotiating table with eyes wide open. You understand that this is your stuff and this is my stuff, and here's, we're going to add to it as a joint situation over time, but that's going to kind of be pile C. So you have your stuff, I have my stuff, and then we have our stuff. And this is how we're going to do it. But as they lock that agreement in place over time, you've already had the difficult conversation about protecting those inheritance rights or those kind of things that could come down the path later on, or protecting that which was really for that prior family unit from the new family unit, if you will. And so, again, so many little nuances in there that each situation really is very fact dependent and personality dependent. And there's so many little things that come into play, especially when you're talking about, sign this agreement before we get married. So it's just kind of an awkward conversation to have, but an important one. And I think kind of the stigma around that process is going away over time as people kind of think about it, especially in the second marriage scenario after the first spouse has passed away or something. And in fact, a lot of the trusts that we build for folks have remarriage protections built in. And there's both a practical side of that, and there's what happens if you're later in life and sort of get taken advantage of into a wedding scenario. You want to have some protection in there because that's probably wasn't the intended outcome of what you were trying to do.
Right. Competing loyalties is what comes to mind when I think about second marriages and blended marriages. You got a loyalty to the spouse that passed away. You've got loyalties to the children through that spouse. And then you also have loyalties to the current spouse.
Yeah.
And so striking that right balance is critical in trying to achieve those conflicting interests. Yeah. And one way that I do that is sometimes by setting up a Q-tip trust for the spouse, which it's qualified terminable interest property trust. It's for the spouse. It designates that all income goes to the spouse, and then the principle of the trust can be used for the health, education, and maintenance and support for the spouse. So it's there if the spouse needs it. You're providing for the spouse, but then also the remainder beneficiaries of that trust are usually the children of the grantor of the trust. And that is a way of making sure that there's something left over for the spouse and for the kids. And so even though you don't have a prenuptial agreement in place, perhaps that's one way to kind of come to an agreement after marriage and get the same interests taken care of.
Yeah. And they're great tools. I always kind of joke with the clients as we're walking through. There's so many of these acronyms. You kind of feel like maybe you're in the military or something, and the lawyers are prone potentially to just start talking about all this stuff because we have all these creative ideas and solutions to where you're going. But really, it's that really understanding what the intended outcome is. How do we preserve that prior legacy and create the new legacy and support along the way? And so you have, the factual scenario that you find yourself in. Sometimes those are ideal and you're full of hope, and this is just going to be the greatest thing because we're newlyweds getting started off on a new life together. Sometimes you have, the very sad scenario where it's now a spouse has passed away and or a dissolution has happened. And so you have to think through all of those scenarios when they come up and deal with the issues that can arise as a result of that, and keep moving forward. Right? We don't always have the opportunity to just be like, well, we're not going to do anything. So there are rules that apply if you do that as well, and likely not going to be what you actually wanted to have happen if you had your plan.
Right. Yeah, the Indiana probate code will provide an estate plan for you if you don't have one for yourself, and it probably is not what you desire. Well, there are also some ways that you can put some restrictions on how assets are distributed to beneficiaries. One common one that I often provide in my documents is 1/3 of the principal in the trust will be distributed at age 25, and then at age 35, the rest of the principal will be distributed to the beneficiaries. But there can be other limitations besides just an age limitation. It could be contingent on certain events happening. Mm-hmm. And so talk about maybe some of those instances where we might condition a distribution from a trust on certain events happening.
Yeah, in the marriage context, you have to walk a fine line between, hey, you can't get married unless you do this, but at the same time, that would be a possibility to say, you stand to inherit a significant sum of money potentially from my estate. Before you do that and enter into an agreement where half of that, down the road could end up in somebody else's estate, we want to protect that expectancy that you have. And so there can be some of that protection built in to say, look, before that spouse or before that child would be entitled to receive funds, maybe we have to go through a little pre-qualification process and make sure that the trustee is comfortable with who the individual is or something along those lines. And so there's some discretion that can be there. And again, you got to balance, how much of control are you trying to retain over someone else's life, and are you taking away constitutional liberties? And it's not an easy analysis, but the communication required through all of this, I think, is really the key, and the education and training of your children and beneficiaries as you walk through that. But the trust is a really flexible tool for that. So let's think of something that's not even marriage related, but how about a substance abuse problem?
Yeah.
Can you just take all the money if you have a substance abuse problem and spend it on whatever you need? No, there's some protections that are built into place there to account for these scenarios and sort of allow you as the trust maker to say, this is kind of what I would have done if I was still here, most likely. Let's replicate that over time so we can provide long-term for these beneficiaries.
Yeah, and another contingency that I'm thinking of that maybe not as harsh as you have to have a prenuptial agreement in place before any property is distributed to you might be you have to complete a high school education, or maybe you have to complete a 4-year degree if the beneficiary is capable of doing so. That might be more of a common type of contingency to put it into a trust. But, those are the common ones, I suppose. But, depending on how much control the grantor wants to impose on his beneficiaries, you could have other contingencies that are built into the plan as well. So, yeah. Anything else on estate planning for newlyweds, Seth?
There's so much excitement around that I would kind of just say, look, don't major on the minors in a situation where this is happening. Continue to move forward with the life, but get those protections built in place. Start building those good habits in terms of asset management and just thinking through, what happens if something does happen to me? How do I account for that? How could my new spouse help me navigate that scenario if something happens? And, we hear stories about that all the time because this is the world that we live in. And so I tried not to bring in kind of the, this is the discouraging part of life, or this is the worst case scenario in every scenario, because it's only the worst case scenario when it is, and that's not everyone's experience. But it's good to have that kind of counterbalance and some of the more sobering things to think about and get it done and move along. We talk about get the documents in place and the plan in place that gives you peace of mind. So you're not thinking about the documents anymore. Yeah. You're focused on the life ahead.
Yeah. Estate planning is not that difficult. You just got to do it one time and then you'll be good until something changes. But when the change happens, then you'll be thinking about getting it done. So yeah. Good stuff as always, Seth. I always enjoy our conversations here on the Lifetime Legacy Lawyer podcast. How can people get in touch with you?
Me as well, Thomas. It's always fun to kind of chat through these issues and brainstorm a little bit live and as we walk through this. So always a little scary too, because I'm not sure which question you're going to ask me and whether I have a good answer.
Yeah, me either.
But that's kind of real life. If folks want to get a hold of us, we're up here in the heart of Hamilton County in Noblesville, and that's our web address, noblesvilleattorney.com. And I guarantee people are going to ask me questions that I'll have to think about and give them an answer to when they come through that process. So this is good preparation for that.
That's right. I try to keep you quick on your feet. My name's Thomas Vick. The best way to get in touch with me is by going to vicklaw.org. I'm located in the Greenwood, Indiana area. So if you want to get in touch with me, go to vicklaw.org. You can book a call through that website. That's all we got for today, Seth. I appreciate it. We'll talk to everybody later.
Thanks, Thomas.